What does happen if a warship is breached on a protected marine sanctuary? At least 1,000 tons of pure steel piling to enrich and diverse the ecosystem. Here's what happened when the USS Guardian was ran aground to the Tubatahha reefs. It was a big issue then. Subsequently, a writ of kalikasan was filed against the fleet commander. Can they make a claim? Disclaimer: our videos and laws are based on actual cases. The facts stated have been made public through publications and the internet. If any details, especially of the petitioner, defendant, and/or the defendant accused, is offensive in any way, kindly leave a comment or message us in our Facebook, and we will be more than happy to change any details accordingly. First, what is the writ of kalikasan? It is rules of procedure for environmental cases involving violations of environmental laws and regulations. In 1988, Tubatahha was declared a national marine park by the virtue of Proclamation No. 306 issued by President Corazon C. Aquino on August 11, 1988. Located in the middle of central Sulu Sea, 150 kilometers southeast of Puerto Princesa City, Tubatahha lies at the heart of the Coral Triangle, the global center of marine biodiversity. On January 17, 2013, at 2:20 a.m. while transiting the Sulu Sea, the ship ran aground on the northwest side of the south shoal of the Tubatahha Reefs, about 80 miles east-southeast of Palawan. No one was injured in the incident, and there have been no reports of leaking fuel or oil. On January 20, 2013, U.S. 7th Fleet Commander Vice Admiral Scott Swift expressed regret for the incident in a past statement. Likewise, U.S. Ambassador to the Philippines Harry K. Thomas Jr., in a meeting at the Department of Foreign Affairs (DFA) on February 4, reiterated his regret over the grounding incident and assured Foreign Affairs Secretary Albert F. Del Rosario that the United States will provide appropriate compensation for the damage to the coral reef caused by the ship. By March 30, 2013, the U.S. Navy-led salvage team had finished removing the last piece of the grounded ship from the coral reef. On April 17, 2013, a petition was filed. Issues: whether or not a temporary environmental protection order, TPO, and/or a right of kalikasan can be issued. Decision: the petition for the issuance of the privilege of the right of kalikasan is hereby denied. The immunity of the state from the suit, known as Doctrine of Sovereign Immunity or Non-Suability of the State, is provided in Article 16 of the 1987 Constitution, which states, Section 3, the state may not be sued without its consent. In the United States of America versus Judge Quinto, we discussed the principles of the state immunity from the suit, as follows. The rule that a state may not be sued without its consent, now expressed in Article 16, Section 3 of the 1987 Constitution, is one of the generally accepted principles of the international law that we have adopted as part of the law of our land under Article 2, Section 2. Even without such affirmation, we would still be bound by the generally accepted principles of the international law under the doctrine of incorporation. Under this doctrine, as accepted by the majority of states, such principles are deemed incorporated into the law every civilized state as a condition and consequence of its membership in the Society of Nations. Upon its admission to such society, the state is automatically obligated to comply with these principles in its relations with other states. As applied to the local state, the doctrine of state immunity is based on the justification given by Justice Holmes that there can be no legal right against the authority which makes the law on which the right depends. All states are sovereign equals and cannot assert jurisdiction over one another. But the doctrine appears to prohibit only suits against a state without its consent. It is also applicable to the complaints filed against officials of the state allegedly performed by them in the discharge of their duties. The rule is that if the judgment against such officials will require the state itself to perform an affirmative act to satisfy the same, such as the appropriation of the amount needed to pay the damages awarded against them, the suit must be regarded as against the state itself even though it has not been formally pleaded. In such a situation, the state may move to dismiss the complaint on the ground that it has been filed without its consent. Under the American Constitution, the doctrine is expressed in the 11th Amendment, which reads, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state." This traditional rule of state immunity, which exempts the state from being sued in the courts of another state without the former's consent or waiver, has evolved into a restrictive doctrine which distinguishes the sovereign and governmental acts jure imperi from private, commercial, and proprietary acts, jure gestonesis. Under the restrictive rule of state immunity extends only to acts jure imperi. The restrictive application of state immunity is proper only when the proceedings arise out of commercial transactions of the foreign sovereign, its commercial activities or economic affairs. In this case, the U.S. respondents were sued in their official capacity as commanding officers of the U.S. Navy who had control and supervision over the USS Guardian and its crew. The alleged act or omission resulting in the unfortunate grounding of the USS Guardian on the TRNP was committed while they were performing official military duties, meaning that the satisfaction of a judgment against said officials will require remedial actions and appropriation of funds by the U.S. government. The suit is deemed to be one against the U.S. itself. Article 197. Cooperation on a global or regional basis. States shall cooperate on a global basis and as appropriate on a regional basis, directly or through competent international organizations, and formulating and elaborating international rules, standards, and recommended practices and procedures consistent with this convention for the protection and preservation of the marine environment, taking into account the characteristics of the regional features. And the relevance of UNCLOS to the present controversy is beyond dispute. Although the said treaty upholds the immunity of warships from the jurisdiction of coastal states while navigating the latter's territorial sea, the flag states shall be required to leave the territorial immediately, if and are liable for damages caused by their warships or any government vessel operated for non-commercial purposes under Article 31. As it is, the waiver of state immunity under the VFA pertains only to the criminal jurisdiction, remember the Pemberton case, and not to special civil actions such as the present petition for issuance of a writ of kalikasan. In fact, that can be inferred from Section 17, Rule 7 of the rules that a criminal case against a person charged with a violation of an environmental law is to be filed separately. Rules. Section 1. Reliefs in a citizen suit. If warranted, the court may grant the plaintiff proper reliefs which shall include the protection, preservation, or rehabilitation of an environment and the payment of attorney's fees, cost of suit, and other litigation expenses. It may also require the violator to submit a program of rehabilitation or restoration of the environment, the cost of which shall be borne by the violator, or to contribute to a special trust fund for the purpose, subject to control of the court. In the light of foregoing, the court defers to the executive branch of the matter of compensation and rehabilitation measures through diplomatic channels. Resolution of these issues impinges on our relations with another state in the context of common security interests under the VFA. It is settled that the conduct of the foreign relations of our government is committed by the Constitution to the executive and legislative, the political departments of the government, and the propriety of what may be done in the exercise of this political power is not a subject to judicial inquiry or decision. As held in Bayan, Bagong Alyansang, Mga Bayan versus Executive Secretary Zamora, the VFA was duly concurred in by the Philippine Senate and has been recognized as a treaty by the United States as attested and certified by the duly authorized representative of the United States government. The VFA being a valid and binding agreement, the parties are required as a matter of international law to abide by its terms and provisions. The present petition under the rules is not the proper remedy to assail the constitutionality of its provisions, wherefore the petition for the issuance of the privilege of the writ of kalikasan is hereby denied.